Now, I understand the Minister says she's bringing all records, that is presumably including the existing National Adoption Register, under the archive. Nothing will be excluded, nothing will be shredded, nothing will be got rid of, because it did seem to me that there was a little grey line there where she was saying we're not going to transfer everything because it will be cumbersome and difficult. Now, I'd like to ask, what happens, supposing somebody breaks the agreement? Is there any penalty? What happens to them? I didn't see any penalty. Then, with regard to the compelling reason, I mean, is it really the case that it would have to be a threat to the life? In other words, envisaging the actual death of the person. That's a very high bar to place. There are a number of principles that I think should be adopted. First of all, no adopted person should be asked to sign a statutory declaration before being allowed access. Medical information, of course it should be given. I mean, this is vital. This is the kind of thing that is so important for further medical treatment. All files relating to adopted people shouldn't be given to CHALSA, but to an objective organisation so that it can be maintained. I'd like to put a couple of voices on the record, voices of people who've been in this situation. I've had contact from a woman who says that if the bill is enacted in its present form, it will lead to further stigmatisation and so on and so forth. My own husband's mother was 14 having him, and she was made give him up for adoption. She has no recollection of signing adoption papers, and at 14, how can you sign a legal document without a guardian? I think that's a very good question. At the age of 14, how can you possibly be assumed to have the legal capacity to do this? Removal of the proposed mechanism to provide statements drafted by TULSA in lieu of copies of original records. This information is actual personal information. Why should third parties go trawling through somebody else's personal information and then give them a kind of a digest form? Now, I have another letter, very moving, but I don't have time to put it all on the record, from the founder of the Irish First Mothers group. And these are a very important group of people. She spent, her first child was born in April 1974, and she spent 4 months at the Good Shepherd Convent. She was aged 19. She nursed her child for 7 days, and then it was taken from her. I've had contact from PACT, and they welcomed the bill by and large, but they are concerned about the closing down of the various agencies. There are 6 of them. Here to Help, Cúnamh, Clare Care, St. Bridget's, St. Moores and Barnardo's. And I think it would be a pity if they are denied a role in this, in this area. Removal of the services provided by these accredited agencies will cause uncertainty to the added waiting time for adopted persons, birth relatives and adopted parents. Receipt of birth information, undergoing tracing, having contact with birth relatives can be a very emotive journey. And adoptive parents already have a relationship to these agencies, and this will now be interrupted. So that could be emotionally disturbing for them. There will be a cut in adoption services when demand is likely to increase. The TULSA adoption service, about which we've heard, there are questions about TULSA. They are already overstretched and under-resources. Assurances haven't been given by TULSA that future information and tracing service will be adequately resourced. They'll be the sole provider of adoption information and tracing services, with the loss of considerable expertise, and there'll be a longer waiting time. Information and tracing service will no longer be subject to regulation by the Adoption Authority of Ireland. Now, with regard to the required signing of the undertaking not to contact the parent, this was discussed in committee, as the Minister knows. This was introduced first by Minister James Riley in 2015, the requirement to sign a statutory declaration. It was roundly criticised by 1,400 members of the Adoption Rights Alliance, and also by the Joint Oireachtas Committee on Health and Children. And this is what they said. They said it could find no convincing reason for the inclusion of a statutory declaration in the bill. So here we have authoritative voices saying there is no reason for such an inclusion. Birth certificates, in any case, are already public records, and this is the only group of people who are required to sign such a declaration. I mean, people looking from the diaspora to find their genealogical background and all the rest of it, they don't have to sign a declaration saying they're not going to contact anybody. Big one?
You're out of time now,
oh,
I'm afraid.
Well, I thought you were saying that I had 1 minute.
Do you need time for the Minister to respond?
Yes. Well, I'd like just to make one final point, and that is the advice of Dr. O'Mahony, which has already been briefly referred to by Senator Barczyk. His evidence to the Joint Oireachtas Committee on Health and Children in 2015 was that it would be constitutionally sound for the Oireachtas to legislate to provide all adult adopted persons with unfettered access. That is the judgment of a senior counsel with a track record in this area. And the reliance on the IOT versus B judgment is only partially effective because they were individuals who had not been formally adopted anyway. So I'd like to ask to compliment the Minister on introducing this legislation. Say I'm grateful that she has indicated she's considering amendments, and I look forward to the passage of a much improved bill.